have with us Dr. Surya Tripathi for this, who is an international lawyer, and also he heads the legal services at ICRISAT Hyderabad. So holds a PhD in plant science and also has played a key role in establishing ICRISAT's intellectual property facilitation cell. So this is the final technical session, and we have a speaker who has been on the forefront of training and supporting startups in their IP regimes. So we would request Dr. Tripathi to take this session up, and we'd love to hear him for the last and final session, which we are trying to have as interactive as possible as well. Dr. Tripathi, stage is yours.
Thank you. I think you people want to go early. Then you will have only question answer session. It is up to you. I think my session will be having a little bit overlap with what Dr. Gautam has discussed, but I will share my experience based on our interaction with the startups. At ICRISAT, we have 3 incubators. We have one Biorack incubator on biotechnology, one oldest agri incubator of 2003, DST1, and one digital incubator. So we deal with all life sciences, agriculture, biotechnology, and digital technology incubator. So I support them on a IP part. At ICRISAT, we have a IP center also, which is funded by the Ministry of MSME. We run the few schemes where we are offering free of cost IP filing. So as you discussed that IP is a cost. I suppose if you want to file one patent in India, generally it costs around 1 lakh something. And if you file international, it will be around 4 to 5 lakhs. So many of the startups, they don't have money for filing a patent, trademark, or geographical indication or design. So we support them. We have a scheme for a government funded scheme, free of cost IP support. There are various schemes where they give a reimbursement also, cost reimbursement. So any of your incubatees, startup or MSME, if they want to utilize the IP support, the funding is available. So as Sir has mentioned, funding is not an issue in India now for any success or any failure. If you want to be success, there are various sources of funding. I will discuss about what kind of activities they do. And as Sir has mentioned, many of the startups, they are not serious. They come IP filing only for just they want to get a grant. Some grant, file my IP, whether it's a potential is there or not. Some, they want to showcase to others that I have IP, I have a patent. Some want to get a job, and that's why they want to showcase that I have IP and then I have filed IP. So there are various reasons they come, and we discourage on such kind of a hidden kind of activities where you want to file a IP or get a IP, but real business sense is not there, or you are not a right opportunity you are creating for IP. So now this is the first question. Generally, most of the time, I think those who are IP attorney, they get this. One day, one person is coming and saying that I have developed something. Now I want to file a patent. And once you do a prior research or research, and then you say that already somebody has done. No, this is my innovative thing. How can you say that? This is the most common problem I face when I interact with first time with any innovator. It's a faculty innovator, student innovator, a startup, or a research scientist. Because when they come to us, IP attorney, they don't do their due diligence. They are not aware that how the world is moving, what information they are coming. They do a Google search. In a Google search, you will get the product already in the market or information in the market. They don't do any patent search or any IP search. Even the name also, the trademark, when they come, they will say that no name is available on the Google. They don't do a search on the trademark registry because possibly the product is not in the market, might be coming in the market, or a product is not that is not registered one. So that's the reason that this is a common problem that we face. So whenever you interact with any attorney, when they say that there is some issue in that your invention, please respect that. Don't say that you don't know anything, I have done a search. This is a real case problem. Most of the time when I interact with the startup, I use this slide because this problem is a very real problem where one innovator came and he said he had developed a cotton plucking technology because nowadays manpower is a very difficult problem for agriculture and farming field. ICRI said being an agriculture organization, we understand all these challenges. So in this case, he said that he developed some machine for a cotton plucking using this vacuum based technology, and this technology, he said he has also secured the grant for a manufacturing. Now he wants to go for a manufacturing. But the funding agency has said that please explore the possibility of getting a patent because the funding agency is going to invest money in that. And that's why they approached our incubator. And then I did a search. And then I identified that already patent is there. Exactly same Indian patent by the Maharashtra innovator is there, and so they have not launched the product in the market. It is a case, old case, I think 5, 7 years, 10 years back case. Product not in the market, but patent is there. Now I have taken a print out the patent and given to him. Now you differentiate your technology and this technology. He said it is the same technology. How we can file a patent? This is my technology. So this is the case where you missed that part. You have not filed IP. You have not taken care of your IP. You have not done a due diligence. You were concentrating only on the business part, and somebody has already filed a patent. And because of this reason, despite you have a market, you have a technology, you have a funding, and you have a capability, and you are serious also. But because of this issue, small issue, now you cannot run the business. This was a big debate in my organization. Everybody, even our incubator started saying that you legal people always create problem. Legal people want nothing should happen. That's why nobody is approaching to the legal person. Nobody go to the legal counsel because you create a problem. I said, I am not created a problem. This problem is created by the person that who innovated and who has filed a patent. I have only simple question. Differentiate your technology and technology which has already been patented, patent granted. He is not able to differentiate. My advice is that if you go, then you will go for an infringement, and investor will also be there. Money will be also locked. That is my advice. You take my advice, you reject my advice, or you go for a second opinion. Go for second opinion. But this is a very important aspect when you go for a business. When you go for a IP based or technology based solution, you should consider the IP literature. I am not saying go and file patent, but at least see that are there any technologies in that particular domain or similar to that. Is there any possibility you take a license? If there is a patent is not in India, you can start work, but at least be aware about that. This is another second case. This is also a very, very interesting, very good case. In this case, one innovator who was initially working with the Tata Motors is a part of the technical team of Tata Motors. He was working there and he got separated, and then he came to me one day that he is developing, he is not fully developed, he is developing a technology to improve the efficiency of the automobile engine. Then I asked that why are you working in this area? He said that I have come to the knowledge that industry is looking for something. This is a real problem. Even Tata Motors is also working, others are also working, and this is for four-wheelers and above vehicles, not for two-wheelers, four-wheelers and other vehicles. Then I said, okay, you show me all details, and then I came to know the technology is looks innovative. I am not an automobile, I am a plant scientist, biotechnologist. I am not an automobile engineer, but I consulted with our farm and engineering unit. We have an internal research farm engineering unit. I discussed with them. There are engineers in that. They said, yes, this is a problem for engines, automobile engines, and since they are user, they are not an innovator. They are a user, but they said this is a real problem. Then I said, if that is the case, let me do a prior art search. I did prior art search. I didn't find anything related to that domain. Then I advised him to file a provisional application. You have been, I think your question was also the provisional. Yeah. So what is the value of provisional? So I advised him to file a provisional application. Why? At least block a time. Then he said, no, a lot of work is required. I said, how much work? He said 6 months, at least 6 months of time is required. Despite my suggestion, repeated advice that you file your provisional. He said, no, I will come after 6 months, after completing my work. And then he completed his work and came to me after 6 months. Then he said, now I am ready. Now you file complete specification. Why you are looking for provisional? I said, now you do a prior search. Now I will teach you, because you looks that you are a technically competent. I will tell you how to use a tool. I am not an automobile scientist. So you do your search. I gave him access to my system, all the tools, that is the databases, pay databases and free, and then given a desk also. You sit and do a job. In 3-4 hours, he identified few relevant patents. Out of them, one was the Hyundai patent. It was exactly same the technology he was working, and it was filed 3 months before. And it was expedited examination, and it was published in Korea with a PCT application. Now the same question, as an attorney, I have to ask, differentiate your technology with the technology. He said, this is the same technology. They have copied my technology. I said, how can I say that they have copied? There might be a question that you have copied their technology. No, I have shown you 6 months back when I came, I discussed with you. So you cannot trust, you are not trusting me or saying that. No, I said, I am trusting you. But now somebody has already filed, and I was suggesting you to file a provisional. You said, no, not required. Now everything gone? Everything gone. And for him, I also arranged some funding arrangement for it, because automobiles, there some testing is required, some clearance is required for the various regulatory authorities. That also I arranged with the various Delhi officials and others, making him that, because he is a one person doing everything. Good job he was doing. Now see the value of IP. These are the 2 or 3 very real examples which I have faced, where IP has played a very crucial role in abolishing their business thought. They are not able to do anything.
In this same context, can I ask you? So now the company, right, they're a startup company, when they are running out of the incubation rate. I mean, it is natural for them that I am already running short of the funds or money where just to invest it in this equipment, whatever they have to buy. So, and if they go for the IP filing, then they have to spend money, right?
That's why I said government schemes are there. You take advantage of the government.
Okay.
BIRAC scheme he has mentioned. I mentioned the MSME scheme.
Everything. So basically, cost effective manner.
See, you have to calculate. I am not pushing anybody to run for a patent filing. A patent is not, I think, not useful for everybody. But you have to leverage that. When you are going, what I am suggesting, you see. Because he was, in this case, he was aware that this is a big industry problem. And other sort of work.
But he has to spend some 20,000-30,000, right? For filing the patent.
That's why I mentioned that there are government schemes are there. You take advantage of the government schemes. So funding is not an issue at all. And for a filing a provisional is only 25,000, 20,000 rupees. Provisional.
Had he filed the provisional, Hyundai couldn't have proceeded at all.
Filing a provisional means you have blocked that. So if we have to check that who is the first filer, if Hyundai is the first filer, then Hyundai will go. If this person is the first filer in a provisional and then subsequently is going for that and the application is coming for a prosecution, the examiner will evaluate and the first filing date will be the cutoff date. When they will see that already the patent has been filed, the Hyundai application will be, his application will be treated as a prior art. Otherwise, for his application, Hyundai application will be treated as a prior art. So, for date of first filing is the cutoff date.
So in software, I mean, we can accomplish something using various methods, right? Though there is a product outside in the market, but I can achieve it with my own technology and I can achieve the accuracy. So, though there is a product, can I still apply for the IP and
Process patent. You will not get the product patent.
oh,
You can get the process patent.
process?
Software.
Software is a tricky one. Yeah.
Very tricky area. Software, if you look at the key of indicating that, it says software was C. So there are what technical learning input comes and anything from the hardware. How? There are even people who can of the side and look for cases. There are tons of people which are running. And software comes to categories. There is a certain thing machine. Either you see the system is not your running, which means that hardware to run. Another is execution. And somebody was very cautious not to use it. And drafting a bill is not law or science. It's art. And there are, or I always said that people that they drop software, there are certain words which should be avoided. And these words become very important. It is possible, like the things like Dr. Reddy was saying, why? You can buy from both sides.
So software patent, if you read the law, plain law, software per se, as sir mentioned, is not allowed. It is coming under section 3. Invention is there, but it is a non-patentable invention. Science is there, invention is there, but under the law, this is a non-patentable invention. This is covered under where? Copyright. But if you can link it with the machine and make it an integral part, it is increasing the efficiency of the machine or something, then it's a combined, then machine, as sir has mentioned, the hardware linked with the software as a composite, you can get a patent. That's why you need attorney. That's why our role is required.
How it in case of AI?
Not the reason for that. Automation. Not the reason for that. Is this something which can be done manually? Or you want to go through a program or an algorithm? It's not enough.
That is one alternative.
These days we have models as well, right? AI and ML
See,
models.
in sir has mentioned, in law everything is possible. You have to just justify and convince. If you can convince, bad case you can win, and that's the reason you see district court case, high court case, Supreme Court review case, 3-bench case, 5-bench case, 13-bench case. Why this is happening? Judgments are being overruled. Patent office judgment being overruled by the appeal. That is overruled by the High Court, overruled by the Supreme Court. It depends on the attorneys, it depends on the evidence, it depends on the information and the fact of the each and every case. And many a times, political thing, policy issue, cross country, global, all these things also play. Like anything related to pharma will be seen very strictly. Anything related to agriculture, seen very strictly, because this is a pharma and agriculture is very, very important for a country like us. Another example that I want to give, that where we are discussing about how IP can be used post IP scenario. That is also again my practical example, because most of the issues already Dr. Gautam has covered. I am not going to cover in detail. So I am a part of the Department of Science and Technology, various government committees. They evaluate the project. So I was evaluating one project at the IIT Delhi, where women scientist scheme. In that, I identified one woman scientist from the Nagpur doing a great job creating some pharmaceutical chemicals and others for mosquito and others, insects, you can say insects, from the herbal sources like orange peel, flowers and others. It's looks to me very good. And then I suggested that why you don't file a patent. She said, I don't have that same question. I don't have money for that, and this is government scheme. This is a fellowship scheme. There is no provision for that. He said, okay, you come, we will support you. We supported. We filed a patent. She got a granted patent. Then she said, what to do? By the time her fellowship also expired, I said, do you have any job? No, I don't have any job. Then we advise you start your business. Then she started her business also. And the many trials in Hyderabad also, because for this mosquito and others breeding ground, the municipal officials or their workers, they are using the chemicals. And that is a very dangerous and harmful for the workers, those who are going into the ponds and other area. So we took the help of the department, used a drone, and then spray the chemical also. It was very effective. Now she started getting orders also. We help them registration of trademark also, registration of the company also. Everything going very good, and she started getting business from Maharashtra, from Telangana, from Kanpur, from many other places where the insects are the big problem. Now, after a few years, I think at 2 3 years, then both husband and wife again they came to me. Yes.
The patent was filed and granted, which is
Applicant of the lady.
he went down to the applicant also. After funding,
Not the DST call, we took a NOC from the DST. DST wanted to, yes, something is going, it's good. Not the funding. So this was not a part of the university.
somebody else wanted that one.
Government of India.
Government, DST and DBT.
DST, they said that, okay, we are okay with that. We will not provide a fund, but we will not claim the IP right also, but you go ahead. NOC they gave.
Another important point.
Organization and funder, that you have to keep in mind, applicant. So in this matter, after 3 years, they both husband and wife came and they said, now because of this patent, the lady got a job in the Nagpur University. Now she said, now I have a job. That is the one issue. I said, very good. At least patent has given something to you. It has given money to you. You have given a recognition. You have given a business. It has given a sense of ownership to you. Now you are feeling empowered that as a lady I can do everything. Now what do you want to do? He said, we are facing a challenge. To certain level, we are not able to expand. We are not able to scale up. Now what should we do? Now I am again going to join a job also, because that is a permanent job as a faculty job. There also, because of this, I am getting an additional grant for setting up incubator also. That's very good. Now, then I advise, if your family is not able to scale up, you are not able to take it further, you are an innovator, you again want to go back to the innovation, scientist part, then you license it. So then they have a license to the very big company, testing trial, everything, because she already did all the trials convincing to the JHMC and many authorities. Already she did a lot of trials, data was there, and successfully license also done.
Sir, how did she approach her, or how did you guide that, you have a patent? Now, somebody may need the license as well, but there's a passion just to build, right?
She identified. So for that purpose we are not have, but we have been drafting and guiding on the term sheet and the agreement and other thing.
Television.
Correct. So
She became popular and the companies are also, because she got a lot of award, IIM Ahmedabad award, this award, so she was, I think, became very popular. Companies also looking for such kind of thing. So for startup, there is a lesson that don't try always to become a businessman. If you think that somebody can acquire your company or a technology, get a patent, license a patent, do your own business, back to your research, go back to your lab. So this is another. So these are 3 examples which can give you an idea that IP can play a very critical role in your life, or the business or academics, any area, but you have to get a right advice. You should not get biased by something or guided by something. I have to file a patent. He has filed patent. I also want to file patent. He has become a startup. I also want to become a startup. Opening a company is very easy, but closing a company is not easy job. So, can you identify how many patents here? How many IP, I would say? Any idea?
Design.
Any idea, rough idea, how many types of IP?
More than four.
Uh,
One is the design.
design,
Trademark. Or
trademark,
method or process.
process,
Technology. And the product also.
product also. So in one invention, one device, that one final device, there are many IPs. Don't think that you file a one patent and by that patent you will do everything. And that's why when we design your IP portfolio, not restrict only for a patent. We talk about only patent. Patent is only one subset. So there you can see the patent in the battery also, in the motor also, the filtration mechanism, brush, I mean, so many. Trademark you can see, the copyright you can see, software, user manual, display, interface. Design you can see, wheel design, dustbin shape, body, and so many. This is just illustrative example that in one device, final device that we see in the market, that is not a composed of only one patent or one IP. There are multiple IPs, and that's why I think Gautam sir has mentioned that when you plan as a part of the strategy, you think big. You try to cover as much as possible, and if you are not able to get the patent, at least a trademark is there, design is there, some other IPs are there. You focus on that. What is your domain? What is your convenience? Now, what kind of problem which I face, see, one by one I will go, that already I mentioned, you don't do prior art. Prior art means searching whatever knowledge available in the public domain, whatever. So as a researcher, those who are researcher, when we write any manuscript, we go and search the literature search. In the literature search, you add a patent literature search. There are so many patent databases freely available. Most common is a Google patent. Go and search on a Google patent, not a Google. Google patent, even for this device, you will have thousands of patents. And full information is available. Now you see, do you want to invent, do you want to improve, or take the particular license or technology and practice? The second, I think already we have discussed that in the morning session we have discussed that we disclose everything immediately. This happens with the scientist. They are rushed into the publish. And for a startup, you can say that I have to start a business. I am not here for a IP another thing. I want to open my business and I want to attract investors, do business. Just file a provisional, then go for a business. Or if you are going for an investor pitch, at least have a non-disclosure agreement, something confidentiality. It should not go to the outside your public room. But such kind of gathering we should avoid. If our business model is based on a technology or invention. This is another problem, that whatever your IP lawyer is saying, you are following. Either you are not listening at all, or you are listening too much. So that also you have to think that what my IP attorney is saying, whether it's useful, meaningful for me or not. How much it will cost? If you go for an international filing, 10 lakhs, 5 lakhs, do you have a budget for that? Do you need for that? So because IP attorney is getting money, so if he is getting money, definitely we say do this or that also. But you decide, you take a call, and that's why basic knowledge of IP is very much required. Basic knowledge. Again, it's if you many times I have seen that 15,000 somebody is charging, and then that's why they are drafting a patent application. So doctors, lawyers, you can get 100 rupees also, thousands also. Sir has mentioned crores also, crore per day also. So you give value, the amount of money you will give, the quality you get. But definitely you go on a trusted organization, the trusted entity. There are so many setups, government bodies are there. Those who are trusted, they offer a quality services. But don't say that some online I am getting trademark in 2,500 rupees. I will go. Then the quality of your work also be like that, 2,500 rupees only. And the ownership. This is a very, very important question I have seen, especially when there is a dispute between the partners. You establish your company and there is no proper IP arrangement between your partners, company owners, co-owners, and your employees. When there is a dispute, who will own what part? Then the issue will come. many, especially in the startups. But that is another reason for failure of startups. They, after a few years, when the company is growing, the money is flowing, then dispute will start. And then after that, there is no clarity on the arrangement, financial arrangement, IP arrangement, legal arrangement, then everything will collapse. Then we have discussed that you want a India, you want a global, which country, where you want, do you have a business? First, you analyze your business proposition, business, whether business is there or not. Just, I can give you one example. At Ecrisat, we file a one patent. The costing of the patent for international was 4 or 5 countries, 60 lakhs rupees. Renewal is coming 12 lakh rupees. See, the huge amount of investment is there. If you are not getting, why we are able to survive? Because that was a filed and taken care by the partner, not by Ecrisat. Ecrisat does not have that amount of fund to invest in that.
Very clear. If you have an ROI,
Yes.
you go for it. If you don't have an ROI, then just handle to glorify your CV.
IP is not for a CV, IP is not for just for a fun. If you have a business interest, you can earn. You go multiple patent, multiple countries. But if you do not have a earning, don't go. I will not advise. And then record keeping, you have to make a proper record. Because there is a dispute between the employer, employee, your peer group, your partners, your funder. And then timeline and cost. You undermine that. Once you start, once you enter into this, litigation sir can tell that. Once you start litigation, it is a huge cost for litigation. So it is not that, and once you stop, you can say that I am going back. So it may take a 3 years, 5 years, certain litigation 10 years, and the cost is also depending upon the time. So estimate, make an estimate of that IP, time, and other thing. And the partners right, what is your right? Sir has mentioned what is the donor right. You be mindful of that. Recently we had one case, very recently we had one case where one PhD scholar approached to us filing a patent and said that my PhD supervisor has agreed for that. When we did some background search, we came to know the PhD supervisor has been separated, retired, and the scholar has completed work. Now they are saying that, if you want to file a patent, this work was funded by the government, funding was given to your institute, you get an NOC from your institute, then only we can do. Otherwise, they will say that Ecrisat is promoting such kind of thing. I talked to the professor also. Professor said, no, I am no more with the organization. I am retired. I said that you retired, but this work was done when you were in the role and the funding was given by the government. So you get the copy of the agreement on which this was funded and the NOC from the university. Then when we approach back to the university said, no, we want to become an applicant, not the professor. So that is also very important. Trademark.
In this case, partners case, right? There are 2 partners, and then when you apply for the patent, and inventor's name will be there, that is patent. Inventors are.
See, law is very clear, not on your financial contribution. It is based on a technical contribution.
Yeah, yeah.
If you are a co-inventor, then you must have contributed technically. Then only you can become a inventor. On a financial side, your entity can become a applicant, or 2%, 3% can become a co-applicant.
Sir, Ram or Shyam, they are the co-applicants, or primary applicant and co-applicant. They are working in the company XYZ. So when the application, there are 3 partners.
Ram and Shyam is a co-inventor. There is a inventor number 1, inventor 2, working in a company. Company is the applicant. Company is the owner.
So now the company has 2 partners, then it's a asset for the company.
So then your company has to take a call that when your assets are being divided, then you divide that also, because IP has a value. So what is the valuation? How the IP rights will be given?
Okay, so then those things may not be well defined between the partners.
Yeah. Many cases what happened that I am an inventor, I am an applicant also, I am the owner. Now we have formed the company. Now I have assigned a license to my invention to the company, and I am earning out of the company. They are very small. So trademark, sir has mentioned, now what we do, many a times we get a request My name of the company is this. Now I want trademark on the that name, which is a very wrong approach, because for a trade company name there is a separate entity, separate authority is there. Registrar of the company, they will give name. For a trademark you have to search from the trademark registry. That is the first thing. Second, one company may have a multiple trademarks. Like for Maruti, all their models they have a trademark. So many models are there, and your trademark should be unique. It should not be like others. But many a time my sentiments are like that. My father want this, my village want this, and that's why you become a very generic kind of trademark where a high potential for a litigation and high potential for a rejection. If your trademark is very good, nowadays government of India is giving 30 days. 30 days they are approving. It's a very remarkable achievement from the government side. But if it is not a good trademark, then examiners are asking a question, examination, cross examination, the hearing, it's taking a 6 months, 1 year, 8 months. Freedom to operate already I have discussed. If you don't do a freedom to operate, you don't know where the problem will you land. You total focus on a patent, you neglect the design and copyright. So all the points I have. Renewal deadline and compliance requirements. So like trademark you have, trademark is a perpetual, but you need a every 10 years renewal. For a patent you need a renewal. If you don't pay the fee, government wants money, IP means money. If you don't pay fee, then it will be abandoned. Very quickly I will go, already we have discussed about that. You take a advice, if you read all these aspects, you take a right advice and work on a right problem. Identify your strength, and wherever needed, don't hesitate to ask and take help. In this world, nobody is perfect. I am also not perfect. Sir is not perfect. He is also, Dr. Reddy is also not perfect. Why? Because all of us are learning. You see that previously we were working on a indirect taxes, so many. Now GST came, everybody started learning GST. So all the lawyers, stalwart, now they have to read the GST and make their learning tuned to the GST law. Similarly, this new criminal cases. No, so we have to read a new law and adopt ourselves. Same thing with the other guidelines, AI and ML. This is a new technology, altogether new technology. Nobody is aware. Judges are not aware, courts are not aware, innovators are, even in organization like ICRISAT, we are suffering. We are not able to identify that how to tackle this ethical issue. Our scientists are using a chat GPT and writing a manuscript. They are writing a publication, they are writing a proposal, and even my interns, I take a legal interns. Now the new interns, they are coming, you ask them to prepare a report or a case summary or something. Within 15-20 minutes, they are coming back. I am surprised to see that how you are coming. Then I am using which tool you are using, because I can see. Even full day, if I do a full day search, case law search, I cannot create a 1 page or 2 page summary of the case law. You are coming in 15-20 minutes. That means you have used some tool, or you are expert in the particular domain. So everybody is now running, everybody is using, but they are not following the correct process procedure. So I think, sir, you have mentioned that there is a risk of losing creativity. So we are not the best, but at least we are evolving, we are learning through our experience and other things. So use all these things as the tool to refine that. We are using this tool to give a better presentation to you. It should not happen that this should replace me. Otherwise, you will not be able to understand. So we have to use a tool very mindfully. But what is happening? Everything we are learning. So nothing is perfect. As Sir has mentioned, don't try, I know everything. You don't know everything. Because many other aspects I don't know, many other aspects others don't know. I think thus, if you have any question, you can ask. Already I have discussed.
Just wanted to also add to that, it's changing so fast. It will take time to stabilize, right? Even after the horse carriage, it took ICT engine almost a century.
We do not have time for that. The time we saw that anything in happening in 3 years, 5 years, 7 years, that is not happening now. We are very quick, very quick.
It is a relative subject, sir. If you talk about human extinction, then that's a different timeline. If you talk about-
I'm a lawyer, so I talk in the law and other science also, not in a philosophical thing, but we have to be ready for matching the time. Time will not wait for us.
You can wait. You can be slow. You can somebody else. Regarding law, law has always been a solution. Because technology is a forerunner. You can't have a law for tomorrow's technology. Law has always been a follower, will remain a follower. It's technology which is a
that's a, for it to stabilize, it will take some time. When does it mature and stabilize?
See, by the time you stabilize, get accustomed to the iPhone, new version is coming.
Yeah.
After again, you take 1 month to adjust the new version. By the time new software update is coming, so the current word is not giving any opportunity to stabilize. They are saying keep running, keep running. Okay, thank you. Yeah.
Those two cases, wherein the idea was already discussed for provisional patent application. I just wanted to know, was there any outcome in that? I mean, did they follow up with those ideas or they were just abandoned?
They have not come back to me, so I am not aware. After that, they have not come back to me.
So, is there any technically specific technology which is allowed for startups or it is agnostic?
See, it's open for all. And one thing I want to highlight: when we advise, we do not. Our advice is not limited to the information provided by you. Like any matter related to this science, we have a ICSAT expertise. We discuss with them and give an opinion how you can expand, how you can add more testing, more scenarios, more options, so that make it patentable. And then we have empaneled firms. They have a different domain expertise. So we are not limiting to domain, but definitely our preferred domain is a life sciences, agriculture, or agriculture machinery, agriculture, food sciences, food technology, because that justifies our work, why we are working. We have to justify to the board and the government that why you are working in another domain. So we work in agriculture and allied sector. Then only our function is justified. Otherwise,
Individuals or institutional individuals.
firms also. So because I am a legal person, so I have a lot of job. I cannot do everything. They are like startup. They have a lot of queries. They want half day meeting another thing. So primary meeting I do. I track every all process. The end meeting, problem resolution, and all those things. The rest of my team and the other attorneys they manage.
Thank you.
Thank you so much, Dr. Tripathi, for the address. We request Dr. Sarkar to kindly felicitate Dr. Tripathi with a memento.
all things of your cities.